Hello, my name is John Yates and I chair the technology practice at Morris, Manning & Martin. And I'm here today with Daniel Sinaway, who is an attorney in our patent IP group. And we're talking about a very important topic for entrepreneurs, that is the America's Invents Act. America's Invents Act is a significant set of laws that will impact technology companies across the board. So we wanted to give you a quick primer in that regard. Let me also say as a starter that if you have specific questions, you should consult your attorney. And so what we're giving today is really a good overview of what the Act says. So Daniel, first of all, thank you for joining me.
Thanks,
and give us a quick overview of the America's Invents Act. What is it about?
So the America Invents Act was a significant patent reform change that first went into effect September 2011, and provisions went into effect over time until recently. The most significant change was March this year, March 16th of 2013.
Okay, I want you to highlight in that regard what you would think would be the one most significant impact of the America's Invents Act for technology entrepreneurs. If you had to take all the changes, what's the most important change and the one that people ought to definitely take away with from this session?
So overall, the American Invents Act was a change to the patent laws, and the most significant change is definitely first to file. So under the new law, an inventor that invents something, okay, whoever files a patent application first wins rights in that technology. So let me give you an example. Under the old law, say I invented a technology, and say one of my competitors also invented a technology, but they invented it after me. Well, if I delayed and for some reason didn't file a patent application as expeditiously as I should have, and my competitors beat me to the filing punch, that was okay. I could still win rights in that technology based on my earlier invention date. Under the new law, it's no longer the case. So under the new law, I have to file first to win patent rights. I could have been working on something for quite a period of time, and if I delayed filing and somebody else beat me to that filing deadline, then they could win rights in the patent and I could be out of luck.
So what this does then is, because it's now a first to file regime rather than a first to invent, it really puts the premium and the burden on the company to go ahead and file that patent application as soon as possible if they want to secure their rights as quickly as possible. And their ability to rely upon the fact that they invented it first is really not going to give them much comfort. They're going to have to actually file with the patent office.
Absolutely, and we think there's certainly a premium on filing patent applications as soon as you can. Of course, that has to be measured, right? You don't want to simply just file willy-nilly, short patent applications that may not get you anywhere. You still have to be measured in the way you think about it, have a strategic approach to it, but certainly you want to take steps to file as soon as you can.
Okay, so a lot of large companies have a patent process. They may have patent attorneys in-house, they may go through, have patent incentives, but smaller entrepreneurial companies frequently don't. But they're also on limited budgets. What's your recommendation, or what do you generally say to a smaller growing company when it comes to taking advantage of this first to file? What can they do that's economical in order to obtain patent protection?
Well, that's a good question. The first thing to think about is you got to have a strategy in place. So you have to be not necessarily reactive to the law, but you have to be thinking about, okay, now that we are an emerging company or a mid-sized company or even a small company, we're at perhaps a disadvantage as compared to larger companies, so we need to be more strategic in the way we think about things. And so part of that strategy to file applications more expeditiously and effectively and cheaply, frankly, is to file what we call provisional patent applications.
Okay, so the company should in the first instance think about putting together a strategy, sitting down and having a strategy session, and then determining how to file more inexpensive provisional patent applications. Talk about the difference between a provisional patent application and a non-provisional patent application.
Sure. So a provisional application is a one-year temporary patent application. I like to think of it as a way to dip your toe in the water with respect to patent filing. It's essentially taking all the content that describes what your technology is and filing it with the patent office. You don't have to worry about all of the formalistic requirements of a regular patent application. You don't need the legalese that defines what your invention is. Your drawings don't have to meet certain formatting issues. So you can minimize our attorney time and keep the costs and fees low, but at the same time get yourself a patent pending status and some potential rights by filing easily. We can help you through that process.
Okay, so you file your provisional patent application after you've had a patent strategy session.
Correct.
And once that application is filed as a provisional patent application, how much time do you have to turn it into a full application, and do you have to do that?
So you've got 1 year, and if you file your full application within 1 year that Morris Manning will help you with, then you get to claim priority back to the filing date of the provisional. So as if you filed the new one on the old filing date. If you get close to that 1 year and you decide, you know what, this invention's not worth it, the market hasn't gone in this direction, it's not worth our time and money, and you just simply let the provisional application expire and no one knows that you filed, no one can see those documents.
Okay, let's walk through a scenario. Let's just say the technology company comes up with a new idea, it's a new product, and they don't file a patent application. And 1 month later, another company, a competitor, we'll call it competitor one, comes in and comes up with the same technology. It's obviously 12 months, or 1 month later, and they file a patent application. So even though you had it first, they now had it, developed it later and file a patent application. You're both out in the market. What happens if that competitor sues you?
Well, if they are able to obtain the patent and they sue you, then unfortunately you could be out of luck, and you could be forced to the situation in which you have infringed their patent. You may not be able to use the technology that you independently developed and frankly developed first, and they could have superior rights, and simply because you dragged your feet and waited around before you filed.
Okay, you talked about the patent strategy session before for a growing entrepreneurial company. That's sort of the first step. So a company says, listen, I understand that this new America Invents Act puts a premium on filing. I know that filing is important. I realize I can file inexpensive provisional patent applications, but what do I do? So you mentioned step one is this strategy session. What does that involve, and how do you usually conduct a strategy session for a technology company?
So we like to think of a strategy session as a way to learn about our client's technology, take audit of what they've done to date in the IP world, if anything, and then start to think about where is this business going, okay? What makes sense for this particular company? Are they in a patent-intensive field or a market that patents are not that significant? Are there a lot of players in this space? Or do they have outside funding? What are their eventual goals for the company? So we take all these things into consideration and then formulate a proactive strategy protecting their patent rights. It may be that for this company, patents are extremely important. And so we have to file applications quickly and effectively, and over time, get many applications in the hopper. It may be that based on the company, the type of services or products they provide, patents aren't that relevant. And so we formulate a different strategy. Maybe it's trade secret protection. Maybe it's relying on copyright. Maybe it's things that are outside the box a little bit. So the point is to be thinking down the horizon and not react to when something happens with your technology. Oh, shoot, we've been out in the market for 11 months. Do we need to file something quickly? It's thinking ahead across the horizon.
So this patent strategy session then really allows you to develop an action item list of steps to take that you may be able to take to protect your intellectual property. It could be patents, filing patent applications, filing provisionals. It could be trade secrets. It could be copyrights. It could be trademarks. But I guess you can think of it as a menu of intellectual property opportunities, and then you can put a budget and timetable against that.
Yeah, and we want to be good stewards of our clients' resources. And so oftentimes we come out of the strategy session and we've got a bundle of action items. But we realize that it may be difficult to take on these things at once, so we prioritize them and say, these two things are really important, and we could face serious issues if we don't address these. These next 4 or 5, let's over the next year, let's plan to deal with these. And these last few, these are nice to have, but let's budget it and time accordingly. So we really try to listen to what our clients' needs are and make sure that they're going down the right path with their IP protection.
Okay, let's take this idea now. Let's say you go through the patent strategy session, and the first area that the client's interested in is what they might call is in the parking lot. What's already there. And you mentioned a moment ago about the 12 months, filing within 12 months, but I think there's another issue, this 1-year bar. Can you talk about the significance of that in determining what you might be able to obtain a patent on with regard to existing technology?
Sure. So anytime you have used a technology in the public use, or you publicly described it, say in a white paper or document, or you've offered it for sale, that starts a 1-year clock running. And so that 1-year clock, within 1 year's time, you have to file a patent application, or else you lose all patent rights in the technology. And so oftentimes our clients will say, gosh, this is a great technology, our business is really hitting its stride. We've been using this for 2 years. Say, well, unfortunately, there's not much you can do to protect that technology. The nice thing is that oftentimes patents have a lot of value if you can be forward thinking about them. And so in those situations where perhaps one of those issues has created a bar to us obtaining a patent, we can think ahead and say, well, where do you think the market's going? Where do you think the technology will be? And gosh, wouldn't it be great if you could create this product in a couple of years, and we file patent applications around those types of technologies.
So let me follow up on that. So let's just say you're a technology company. You've got some technology that may be subject to this 1-year bar. That is, it's been out in the market. You've been licensing the technology for more than a year, and therefore you can't obtain a patent on that under U.S. law. You've got other technology you may have that's in the hopper where you could file one of these provisional patent applications you talked about, and then you have another year after filing that provisional in which to file the full application. So there's a separate 1-year period. And then what you're pointing out now is that the company may say, you know, we really know this space extremely well, and we think the market's going to go out here. So you're saying that a company could then consider filing patent applications, even though they may not have actually created the product yet, file patent applications in that area where they think the market's going.
That's right. There's no requirement that you actually have to have built something to file a patent for it. As long as you can describe in a document how it works, how it will function, so that someone of skill in the art could understand that document and say, oh, that's pretty clever, I know how that works, that's sufficient. So you don't have to have built a prototype, you don't have to be in development, you don't have to have sold a product. As long as you can think it out, you can file a patent protection for it.
So it probably behooves a lot of companies who say, listen, we're in this area, we really know this space, we know market research in the area, we think the market's going in this direction. They could begin filing patent applications in that area and really building an organized group of patent applications. Is there a way you describe that when clients want to put that kind of a arrangement together?
Yeah, we often think of an approach called a patent thicket or a patent web, where we see their technology and say, okay, you've got it, your core product here, but really there could be 4 or 5 or 10 things in here that are patent worthy. It could be separate patents. And so we will try to maybe slice those things up in a way so that you have smaller discrete patent applications moving their way through the system, which gives you a lot of advantages in the patent front. We think of it as a miniature IBM approach or something along those lines where you can divide up the technology. We're not aware of any other firms that kind of follow that approach.
So Daniel, you've talked about several things. You've talked about first the idea of a company conducting a patent strategy session, then moving from there with this action item list of steps to take, moving toward the notion of actually filing specific patent applications, and then also the idea of potentially filing patent applications in areas where people think the market is going, all of which makes sense as a strategy. Can you just comment maybe finally on what you think this America Invents Act does for entrepreneurs? Is it a good thing? Is it a bad thing? What should people be thinking about with regard to growing technology companies, and is it a problem?
Yeah, I don't know that it's necessarily a good or a bad thing. I think what it is it makes people have to be a little more proactive and strategic about the way they approach IP and patenting. You can no longer simply rely on your prior invention. You can't simply wait for things to happen. You've got to be thinking ahead, because if you don't do certain things, if you don't file more quickly, if you don't pay attention to your competitors, if you don't see how the market's moving, you could really be left behind.
Let me ask one final question. Motivating people within a company to file and think about what might be patentable. Again, larger companies have incentive programs for that. Can you talk briefly about what kind of programs a smaller company might be able to put in place to motivate people to think about filing patent applications?
Sure, yeah, we often implement, we call them invention identification or invention incentive programs in companies. And it's ways to reward developers for coming up with products that could be patentable and alerting the management to those things. And frankly, we've realized that it helps create innovation. It's oftentimes it's not that the developers aren't working on those things, they don't realize they've created something patentable. So it's extracting that information from them so that we can protect it for the company.
Daniel, I appreciate it. I know you've filed, along with your group, thousands of patent applications in the U.S. and internationally. I know also that we're aware that as a result of the America Invents Act, there have been a number of changes that have taken place. It really does place a premium on technology companies to make sure that you have the strategy in place, that you determine what you can file in the way of patent applications, and you move forward with that strategy. And we all know it has to be done within a reasonable budget. So Daniel, thank you very much. We appreciate it. And again, to our audience, we would say that if you have specific legal questions, please consult your attorney. This is for educational and informational purposes, and we don't give legal advice on the video, but we're happy to answer your questions if you'd like to call. Thanks so much.
Thank you.